My name is Jeneline Asuncion, and my topic is about product liability. Product liability falls under the category of negligence. When a product is found to be defective and causes harm, the injured party may pursue a product liability claim to seek compensation for their losses. I particularly selected this case entitled Nicholson versus John Deere Limited et al. From the Ontario High Court of Justice, dated December 19, 1986, because the facts of this case involve a relatable scenario as it involves everyday consumer products and the potential dangers that are associated with them. Primarily, there are three parties involved in this case. It is the Nicholsons, who were the plaintiffs, John Deere, which is the manufacturer, and the Hutchinson Farm Supply Limited, which are the repairers. But who's really at fault for the tragic incident that happened involving a riding lawnmower? Is it the manufacturer, the repairer, or the plaintiffs themselves? Let's find out. But before anything else, let's first take a look at the general details of the case to see how the case started. So, what is the product involved? The product is a John Deere garden lawn riding mower purchased by the plaintiffs in 1976. They've purchased it at an auction and several times repaired by the defendant, Hutchinson Farm Supply Limited of Stouffville, Ontario. The plaintiffs claim damages for the loss of their homes and contents destroyed in a fire which occurred on May 23, 1981. It is alleged that the fire was caused by a known defect in the design of the unit. It was said to be inherently dangerous and is contended that there was a failure to rectify the defect or adequately warn of the dangers. The hazard and potential risk fire arose out of close proximity of the exposed positive battery post and the fuel tank. Few cases have a deep impact as this Nicholson versus John Deere. So, why does it have a deep impact? It is because in 1981, John Deere was a well-established and popular manufacturer of agricultural and lawn equipment. The company has built a reputation for quality, durability, and innovation in the agricultural sector. And yet, here is the case they face, which involved product liability. The landmark case, which unfolded in the Ontario Court of Appeal, centered around the tragic incident involving a riding lawnmower manufactured by John Deere and serviced by Hutchinson Farm Supply Limited. The case not only exposed critical design flaw in the mower, but also raised significant questions about the manufacturer's obligations to ensure product safety and warn consumers of potential risks. But to be on point, the case started when a product liability claim was filed by the Nicholsons against John Deere, the manufacturer of the garden lawn riding mower, and Hutchinson Farm Supply, the repairer. The core issue revolves around the damages caused by the fire alleged to be result of a known defect in the design of the John Deere mower. But here's another thing. In this case, not only the manufacturer and the repairer had alleged negligence claims. Even the plaintiffs themselves were accused of contributory negligence. There were claims suggesting contributory negligence against the Nicholsons because, first, modifying or failing to correct modifications. Allegations were made that the plaintiffs had modified the mower or failed to correct modifications contributing to the alleged defects. Failure to maintain the mower in the safe condition was the second reason. It was asserted that the plaintiffs were negligent in failing to keep their mower in its safe condition. The third one is failure to inform themselves about safe operation. The Nicholsons were accused of negligence for not taking steps to inform themselves about the safe operation of the mower. The fourth reason is failure to obtain and read the operator's manual themselves. The defense claimed negligence on the part of the Nicholsons for not obtaining and reading operator's manual to familiarize themselves with the safety components of the mower. Lastly, it's filling the gas tank inside the garage. The defense argued that the plaintiffs created an increased risk of fire damage to their house by fueling the mower in the garage contrary to the instructions in the operator's manual. But however, the court ultimately dismissed these claims of contributory negligence, stating that the Nicholsons' actions were in line with those of a reasonable consumer, considering the limited foreseeability of the specific danger related to the design defect. Let's now go to the main points of the case and take a closer look at how the case was closed. The design defect and the manufacturer's negligence. The court found that the positioning of the gas tank in close proximity to the battery in the riding lawnmower constituted a design defect. Despite the knowledge of the danger, John Deere failed to rectify the defect or adequately warn the consumers, leading to the tragic fire incident. Second main point is the repairer's negligence. Hutchinson Farm Supply Limited, the repairer of the lawnmower, was found negligent for returning the mower to the plaintiffs without addressing that known danger arising from the design defect. This highlighted the repairer's duty to ensure the safety of the service products. The third main point was the contributory negligence. The court dismissed claims of contributory negligence against the plaintiffs, emphasizing that they could not reasonably have foreseen the specific danger of arcing between the battery and the gas tank. Actions such as refueling the mower in the garage were deemed normal and not negligent. Fourth main point is the manufacturer's duty to warn. The case underscored the manufacturer's obligation to provide adequate warning to consumers regarding potential risks associated with their products. The court criticized the manufacturer's efforts to warn consumers as insufficient and ineffective. To conclude, Nicholson versus John Deere Hutchinson Farm Supply case set a precedent for holding manufacturers and repairers accountable for design defects and negligence in product safety. While the court dismissed claims of contributory negligence against the plaintiffs, emphasizing that they could not reasonably have foreseen the specific danger of arcing between that battery and that gas tank. At the trial's outset, an order was agreed upon to refer the damages question. The appointment of a referee is pending consultation, and the council is urged to liaise with the administration in Newmarket to arrange a date with local masters. Damages excluding general damages for inconvenience, house enjoyment, physical injury due to emotional stress. The amount is fixed in the case of Mr. and Mrs. Hutchinson of $1,000 and $1,500 respectively. The plaintiffs will receive costs assessed and payable without awaiting the reference outcome. The judge acknowledges that the compensation sought covering the house and the content loss is known to the assessment officer, preventing unjust delays in financing the litigation. This case highlighted the importance of proactive measures to prevent harm to consumers and the duty of care owed by all parties involved in the production and servicing of consumer goods. One of the key lessons learned from this case is the paramount importance of prioritizing consumer safety in product design, manufacturing, and servicing. Manufacturers and repairers must diligently assess potential risks, rectify defects promptly, and provide clear and comprehensive warnings to users to prevent avoidable harm and legal liabilities. Moreover, consumers should be vigilant in understanding the risks associated with the products they use and hold the manufacturers and repairers accountable for ensuring their safety.